My name is S.M. Mwenesi for the Law Society, the second amicus. Thank you.
Thank you, Mr. Mwenesi. We are ready. And we have...
Please, you, my lady.
Sorry?
Sorry, I'm sorry to interrupt the Honorable Chief Justice. Lady, my learned friend, Professor Sihanya, has a burning request he wants to put to the court before you begin.
Lady DCJ, my Lord Justice Ojwang, we were in the admission under my pupil master, and it was to start at 8:30, but I think it's been running a little late. So I'll step out briefly because of the function, then just come back. Yeah, I'm sorry about that. Thank you.
Professor, thank you. We have two rulings. One by what has now become the majority, and we have the other by the Honorable Mr. Justice Professor Ojwang. The one by the Honorable Professor Ojwang is a concurring ruling, and so as procedure would require, I shall read the ruling by the majority, and then my brother judge will read his. The ruling by the majority has been signed by all of us, including the Honorable Mr. Justice Professor Ojwang, and it runs into some 25 pages. I want to get your concurrence, whether you require that I read every word of it, and I'm ready to do that, or you want me to read the determination part only.
For the petitioners, we leave it to the discretion of the court, and yeah.
That's true for everybody. All right, let's go. Let's go. Let's do this. The second respondent is the applicant and has moved this court by way of a notice of motion dated the 4th of October 2017, premised upon Articles 138, 163, and 159 of the Constitution of Kenya 2010, Section 21(4) of the Supreme Court Act, and Rule 3, Sub-Rules 2, 4, and 5 of the Supreme Court Rules 2010, and it seeks the following orders. A, that the court be pleased to certify the application as urgent and to hear it on a priority basis, and B, that the court be pleased to correct and or clarify its judgment delivered on 20th September 2017 as regards 1, which results as between the tallies contained in Forms 34B submitted by the returning officers to the National Tally Center and the totals of Forms 34A as verified by the first and second respondents, the second respondent should use in declaring the results of the presidential election as envisaged under Article 138(10) of the Constitution. 2, whether the first and second respondents can correct errors identified in Forms 34B and or amend the Forms 34B where the same differ with the results contained in the relevant Forms 34A after the